Today, the Justice Department is launching a broad civil rights investigation into the Ferguson Police Department. Ferguson, of course, is where unarmed black teenager Michael Brown was killed by a police officer. The investigation is going to look into whether or not Ferguson police practices overall violate federal law. Now, this comes as two different media outlets sued to unseal Brown's juvenile record. Why? Well, they argue that it is relevant to covering the story. An official, while not confirming a record exists, says that Brown had no serious felony convictions pending. So convictions or any charges pending. So what does that mean? What's the motivation to have these records released? Is it a better understanding of Brown's death, or is it a way to justify character assassination, basically? Let's take a look at these two issues. We have Danny Cevallos, CNN legal analyst, criminal defense attorney, and Mo Ivory, an attorney and radio host. Thanks for having you here. Let's, first of all, point of order. It's not just the Ferguson Police Department. They're going to be looking at police departments in the surrounding St. Louis area. Mo, let's start with you. Let's talk about this civil rights investigation. This goes to the major complaint on the ground there. It wasn't just about Michael Brown. It was about this being a reflection of a culture of policing felt in that community. What do you think about this? Is it how much show versus go is this investigation?
Well, I mean, I definitely think it's important for this investigation to go on. It's the kind of investigations that, civil rights attorneys have been calling for a long time, not to just look at one particular case, but to look at the systemic problem. So I don't think it's for show, but I think at this moment in time, the focus, what happened in Ferguson, all of the things that have happened have put such a spotlight on something further, something going a little bit further than it has normally done, which is every state, handling these cases case by case. And really time for the federal government to step in and to say, we're going to look at this as a systemic problem, not only in St. Louis, but in any of these police departments that have, continued to have a problem. So I think it's a very important case. And I think that, hopefully it'll have some widespread ramifications.
Sounds good, Mo Ivory. Danny Cevallos, tell me the last time a federal investigation of this kind yielded change.
Yeah.
Can you?
Well, I will say this, that the Department of Justice in just the past couple years has pretty much doubled its investigation of agencies. But you might be surprised. It's not in the hundreds or the thousands of agencies. It's in more like the tens and the 20s, because the Department of Justice simply doesn't have the resources to investigate each and every one of these claims. And it's important that when the DOJ investigates, they will be looking specifically at a history, and they have to prove a pattern or practice. They need to look at the overall picture
based on
that's
race.
What the statute
based
requires.
on race.
Yes.
You have to show.
No, not based. No. Everyone, please listen. The statute requires a deprivation of constitutional rights or federal law. That can include discrimination, but it need not include discrimination. It can be merely a pattern or practice of excessive force or other police misconduct. So while a showing of race is important and it may be relevant, it is not required. We must make that clear.
Why must we make it clear when the point of the investigation to that community and communities around the country, Danny, is that we think if we're black, we get treated differently by police? You think people will be satisfied if this investigation yields that, police aren't nice to people driving red cars? Mo Ivory, what's your take?
No, absolutely. I mean, there's a difference between trying to set forth the requirements as to the strong case, but these cases end up happening because of the very nature of why they're there, because of racial hostility. So obviously race does play a key factor in it. They wouldn't be coming in under these statutes, Danny, if race wasn't a part of the issue. I understand what you're saying about the legal requirements, and there are many, but race certainly plays a role.
My question to you, Danny, was we have to be realistic about what we expect to come out of this investigation, right? Because that was also a little bit of A.G. Holder's promise that he was going to investigate this shooting as well. And we wanted to lower expectations at that time because they're still looking at Trayvon Martin's shooting. And a lot of these investigations don't yield results. Fair point, Danny?
Well, there's two kinds of investigations. Under the law, if there's a criminal allegation against the individual officer, they can focus on this one incident.
Right.
And again, that criminal investigation does not require a racial component. It may, and certainly, in fact, Mo and I apparently agree on that element. If there is a racial element, that bolsters, that strengthens the federal case. But we need to understand that it's not required. And in a way, people who are calling for an investigation should be glad to hear that, because it expands the jurisdiction of the Department of Justice beyond simply a showing of a racial component, but to a broader, if there's a pattern or practice of, say, excessive force. That, too, can be violative of the law. The law encompasses a number of other federal laws and federal violations beyond just race.
Sure, but Danny and Chris, it's important to say that most of these cases arise out of a racial component. So we can't dismiss that. It gives the broader sense of being able to allow a lot of things to come in that might not necessarily be racial, but in America, it's most likely racial.
Right, and you don't want to seem like you're slipping the race issue by pointing out something else. But Danny, your point's well taken. It's broader than that, and hopefully that will give confidence that they'll be looking at a wide range of behavior, make sure the culture's intact. All right, let's get to the second point very quickly here. Danny, you tell me why these records should be released, and Mo, you take the other side of why they shouldn't. The kid's juvenile record, that which happened before up until when he was 17. What's the argument for releasing them?
I like the response of the government attorney in this case when they announced that he has been not been convicted of any A, B, or C felonies with a prior record, because under the statute, that would make his record public. What they are sort of implying in the negative is that he may have something in a minor misdemeanor that should not be released unless the Post-Dispatch can show a legitimate interest. So the question really is there a media legitimate interest in a deceased juvenile's records? If they can make that showing to a court, well then, under the law, those records can be released.
What would be a legitimate interest?
But be mindful, if he had been convicted. Well, you know, that's a good question, because I think it's going to be a case-by-case basis. I've looked at, hold on, Mo. It's not necessarily nothing. The media has a compelling interest in determining court records. It's nothing in your opinion, and that's interesting. But the court may have a different opinion when they apply the law, and that's what we need to apply.
But what would be the legitimate
interest?
What would be the legitimate interest?
So the argument is, it's not my argument. So the argument is that the legitimate interest is a deceased juvenile no longer has the interest in keeping those records private that the law was designed to protect. The law is designed to protect a juvenile's records from disclosure because it might harm that juvenile. And we understand that juveniles sometimes do silly things and they should be protected. But the argument that the media has here is that because he is deceased, that interest no longer remains, and therefore the media's interest in discovering those court records override. It's not my argument. It's the petitioner's argument.
Look, I understand it's a volatile issue, and but we got to lay it out because people have to understand what's going on and what the choices are. Mo, what's the other side?
The other side is that there is absolutely no interest for a media outlet to know what is in Michael Brown's juvenile record. And I understand that this is not Danny's opinion, but that is what the other side would argue. And there just is no interest because this case is wide known or because it's gained national attention. The very core of the reason is to protect the privacy of a juvenile, and that should be protected at all costs. There was a 1984 case in Missouri that the media continues to refer to, but that case is entirely different from this case. The people were a party to the case that brought the request for the records, and it was in a civil matter to figure out damages. This is completely different from what they're trying to do to Michael Brown. This is a media outlet trying to break a story. This is a media outlet trying to get information so that they can be the first to break a story that is completely irrelevant to the case. So I really hope that this judge does what the law says, which is protect Michael Brown's juvenile record. And so we will see what happens.
And just for your own heads out there as you're watching this, remember, we've heard the most important thing probably already. The reason you would want this information as a reporter is to show that this kid may have had a predisposition towards violence or to do something that may have endangered the cop. The person advocating at trial said, or at this hearing said, there are no convictions for a major felony of A, B variety, which is legal talk, in the record. And by the way, had there been, which was a point Danny was going to make and I didn't let him, that would have been public anyway. So if there was something of the kind of things that journalists want, it would already be public. It wouldn't have been protected under the law. But I got to go, Mo. I got to go right now. We're going to continue this discussion because we have to hear what the judge says, and then we'll do it again. Mo Ivory, thank you very much. Danny Savalos, a pleasure.